Let's start. The present writ petition has been filed for restraining the tribunal of the Speaker Jharkhand Vidhan Sabha constituted under Schedule 9 of the Constitution. The respondent number 1 to pass a final order in 10th Schedule case number 01 of the 2021 initiated on the basis of the complaint filed by the respondent number 2 on 23/12/2020 without deciding the preliminary objection of the petitioner filed on 23/08/2021. Further prayer has been made for quashing the order dated 30/08/2022 passed in 10th Schedule case number 1 of the 2021, whereby the judgment has been reserved without providing any opportunity of hearing to the petitioner. The petitioner has also prayed for issuance of a direction upon the respondent number 1 to allow the petitioner to adduce evidence before passing final judgment in 10th Schedule case number 1 of the 2021, as well as not to proceed with the case during pendency of the present writ petition or till disposal of the preliminary objection filed by the petitioner. Stop para. Mr. V.P. Singh, learned senior counsel appearing on behalf of the petitioner, submits that the petitioner Babulal Marandi along with Pradeep Jadhav and Bondhu Tirki contested the 5th Jharkhand Legislative Assembly election held in the month of November 2019. Para. It is further submitted that Jharkhand Vidhan Sabha Secretariat vide letter as contained in memo number 1097 dated 15/06/2020 issued by the Secretary Jharkhand Vidhan Sabha Ranchi returning officer of Rajya Sabha biennial election 2020 communicated amended voter list of Jharkhand for the biennial election of Council of State Schedule to be held on 10/06/2020 to the Election Commission of India in the light of directions given by Commission's letter dated 11/06/2020. Para. Learned senior counsel for the petitioner contends that the petitioner had filed preliminary objection on 23/08/2021 with respect to maintainability of 10th Schedule case number 01 of 2021 before the respondent number 1, claiming that the issue involved in the said case was related to merger and not of defection, for which the Election Commission of India had already taken a decision on 06/03/2020. However, the respondent number 1 did not decide the said issue and reserved the case for final judgment by the order dated 30/08/2022. The petitioner had also filed a petition on 17/05/2022 for recasting of issues, but the same was not decided. Moreover, the petitioner filed a list of witnesses to be examined on his behalf. However, the respondent number 1 failed to examine the said witnesses, who were the number of the Central Working Committee of erstwhile JVM within bracket P and had participated in the meeting of the CWC held on 11/02/2020. The respondent number 2 filed certain documents before the respondent number 1. However, without examination of any witness, the respondent number 1 marked the said documents as exhibits on its own, even when the petitioner objected to it. On the one hand, the case says of Pradeep Jadhav and Bondhu Tirki have been adjourned, and on the other hand, the case of the petitioner has been reserved for judgment that too, in violation of the principles of natural justice. The respondent number 1 was bound to follow the principles of natural justice while deciding the issue with regard to anti-defection as provided in the 10th Schedule of the Constitution of India. The manner in which the entire proceeding was conducted by the respondent number 1 suggests non-application of mind, who also acted in an arbitrary manner by not dispensing disposing of several petitions filed by the petitioner para. Learned Senior Counsel for the petitioner also submits that Section 29A of the Representation of the People Act 1951 provides for registration of associations and bodies with the Election Commission as political parties, and in view of subsection within bracket 8 of Section 29A, the decision of the Election Commission is final. In the present case, JVM within bracket P has merged with BJP, and the said merger has been accepted or confirmed by the Election Commission of India by the email dated 06/03/2020. As such, the Speaker Jharkhand Legislative Assembly cannot sit in appeal over the decision of the Election Commission of India on the point of merger, and indirect challenge to the order of the Election Commission is not permissible. Para 15 of the election symbols within bracket reservation of the allotment order 1968 within bracket in short symbol order 1968 speaks about the power of the commission in relation to splinter groups or rival sections of a recognized political party as per the said para. When the commission is satisfied on information in its position that there are rival sections or groups of a recognized political party, each of whom claims to be that party, the commission may, after taking into account all the available facts and circumstances of the case and hearing such representatives of the sections or groups and other persons as directed to be heard, decide that one such rival section or group or none of such rival sections or groups is that recognized political party, and the decision of the commission shall be binding on all such rival sections or groups. Para. Learned Senior Counsel for the petitioner also invites the attention of this court to para 16 of the symbol order 1968 sub-para within bracket 1 of para 16 provides that when two or more political parties, one or some or all of whom is a recognized political party or are recognized political parties, join together to form a new political party, the commission may, after taking into account all the facts and circumstances of the case, hearing such representatives of the newly formed party and other persons as desired to be heard, and having regard to the provisions of this order, decide as to whether such newly formed party should be a national party or a state party, and thereafter decide the symbol to be allotted to it as per sub-para 2 of para 16. The decision of the commission under sub-paragraph within bracket 1 shall be binding on the newly formed political party and all the component units thereof. Para 2 within bracket 2 of the symbol order 1968 provides that the General Clauses Act 1897 shall, as far as may be, apply in relation to the interpretation of this order as it applies in relation to the interpretation of the Central Act. Thus, the power to register a political group also includes the power to deregister it. Stop para. Thank you. Jai Hind, Jai Mera Bharat.
Thank you.